Yeah, you bring up a really good point. When I saw this news yesterday or develop overnight, I kept asking myself that same question: Why now? Why now? Yeah, and I'd be curious if you're speculating a little bit. But maybe put a finer point on that, Don. And then also, for viewers at home who want to track this, there's just grave injustice of miscarriage of justice. I mean, when are the next flashpoints, right? When are the next appeals expected to be filed? Things like that. Give everyone maybe a little something to look forward to.
Well, what's clearly going to happen after United States versus Trump, where we now knew what Nixon versus Fitzgerald said, there was absolute immunity in civil cases. It only made sense to bring it over into criminal actions as well. We now know that the case in Manhattan has been gutted. We also know, I was very happy to read the court's decision in U.S. v. Trump when Justice Thomas sent what I call a little love letter in his concurring opinion to Jack Smith, saying, hey, by the way, Mr. Special Prosecutor, I know that the Attorney General appointed a private citizen to prosecute a former president. We got a little thing in the Constitution, Article 2, Section 2, Clause 2, the Appointments Clause. There's been no congressional authorization for this. And in Florida, Trump's attorneys have made a motion to dismiss, in part because Jack Smith has been illegally and unconstitutionally appointed. So there's a little wink for you, Judge Cannon, if you read Justice Thomas's concurring opinion, to go ahead and knock that out. That may give her a little bit more, gas in the tank, so to speak, to do the right thing and dismiss that case for many reasons. But there's one right there. Justice Thomas gave her a little wink. His appointment is a violation of the Appointments Clause. And, of course, this case now on the J6 case, under which we know there is absolute immunity for official acts, and there's a presumption of immunity for what the court calls acts within the outer perimeter, which the court says if there's speech from a president, and notes that most of what the president's being charged with in D.C. are speech-related, whether it's his speech on January the 6th or a variety of tweets, that's presumed to be within the inner perimeter, and there's presumptive immunity there. So my old friend, Judge Tanya Chutkan, who I've been before on a number of occasions with some of my J6 cases, is going to have to go back, and she's going to have to apply what the Supreme Court has told her. There's very, very little wiggle room for this case that is in D.C. to survive. So we should be seeing a number of motions to dismiss flying within the next week or 2 weeks or 3 weeks from the president's attorneys to dismiss these cases based on these rulings. And by the way, the Trump versus U.S. also absolutely kills Fani Willis's case in Georgia as well, because everything that the president did, for which he's being charged under a Georgia RICO statute, which is a joke, was based upon presidential communications. And even if it's in the outer perimeter, and even if part of the president's motivation is political, he also has a duty and responsibility as the chief executive officer of the United States to make sure that election fraud is not perpetrated. And he has every right to make calls to secretaries of state or anybody else to make sure that there is a fair election. So all that is within the outer perimeter. All that is presumed to be immune, and I'm expecting to see motions to dismiss in all these cases, to answer your question, and soon, probably sooner rather than later.
Well, we certainly hope so. Don Brown, thank you so much. Happy 4th of July to you and your family.
Happy 4th to my wonderful Patriot friends there at Real America's Voice and on Special Report. Appreciate you all.
Appreciate you as well.